honorable guests, my dear friends, ladies and gentlemen, it's a great honor and pleasure for me to welcome you to the 6th International Arbitration Forum in Athens, which, together with the other exciting events, forms the core of the Athens Arbitration Days 2025, an institution that brings together all Greece's annual arbitration events. The topic of this year's forum, IDEST, Contraction, Contracts and International Arbitration, was chosen in light of the fact that in an era of global economic growth, the resolution of disputes arising from construction contracts, particularly through arbitration, represent a significant proportion of the cases brought before international commercial arbitration. Construction arbitration, moreover, possesses certain distinctive features that may be summarized as follows. Cases in this field are often marked by a high degree of complexity and intricacy, frequently involving issues of a highly technical nature. To deal effectively with such disputes, whether as an arbitrator or as a counsel, demands a considerable and often painstaking effort to grasp the multifaceted factual background. In most situations, this effort cannot be carried out single-handedly. It calls for the assistance of various categories of experts, including technical, delay, and quantum specialists. Only through such collaboration can the factual matrix of each case be properly shaped and translated into legal terms, enabling the precise formulation and resolution of the legal issues that arise. In our opinion, all these issues require a closer and careful look. In this context, the theme of today's forum will unfold through 4 panels, each focusing on one of the following subtopics. First topic, liability in construction disputes. Second topic, dispute avoidance and adjudication boards. Third, construction arbitration and state entities. And fourth, procedural issues in construction arbitration. We believe that these 4 subtopics cover all the individual issues of construction contracts and related disputes in international arbitration. In particular, the first panel, chaired by Stavros Brikoulakis, will address issues of delay claims, disruption claims, liquidated damages, exceptional circumstances, and force majeure in construction contracts and cooperation with technical experts. The second panel, chaired by Clement Fouchard, will address all issues relating to the use and usefulness of DABs, their role as a means of preventing and avoiding disputes, the allocation of jurisdiction between DABs and arbitral tribunals, and the enforcement of DABs decisions. The third panel, chaired by Hamid Garavi, will deal with concession contracts and infrastructure projects, various approaches to risk allocation between states and concessionaire construction consortia, national applicable laws and concession contracts, compatibility with national mandatory rules and administrative law, procedural challenges in dealing with states and state entities and post-award states, review of award by state courts, enforcement and settlement. The fourth and last panel, chaired by Stella Leptourgou, will focus on the ICC report on construction industry, which provides guidance on tools and techniques for effectively managing construction arbitrations. The discussion will address the management of large submissions, evidence, and evolving cases, including these of schedules and other practical techniques, as well as the management of experts assisting tribunals, covering pre-hearing management, the role of party-appointed versus tribunal-appointed experts, and the involvement of technical consultants. As you can see, all panels will concentrate on the practical challenges that arise in the context of construction arbitration. The concluding remarks of my colleague, Stavros Berkoulakis, will bring together the common threads and essential takeaways from today's discussion. I'm confident that the distinguished participants of all panels will delve into many additional aspects of the topics at hand, enriching the ongoing international debate. By the end of this day, I am sure we will have gained deeper insights and broadened our knowledge on these subject matters. That said, I would like to deeply thank everyone who contributes to the scientific success of this conference. Without your engagement in fostering debate on such pervasive topics, international arbitration could not continue to evolve. I also wish to extend my sincere gratitude to Sakoulas Publications, especially to Panagiotis Sakoulas and Yannis Papagrigorakis, and also Ioanna Sakoulas, who have made it possible for all of us to come together here, and of course, our sponsors for their indispensable support. Finally, I warmly thank all the moderators and speakers of the panels, and most importantly, all of you, the participants of this year's forum, because, after all, it is your presence and engagement that truly make this event possible. From this inception, the intention of the initiators of this annual forum has been to create a genuine platform for the exchange of views on practical issues arising in international arbitration. Last but not least, I extend my thanks to all those working behind the scenes who supported the preparation of the forum. Holding this conference would not have been possible without your dedication, time, and effort. This afternoon, we will have the opportunity to continue our discussions and exchange thoughts on the valuable insights shared during the forum at the closing cocktail kindly offered by CLF, to which you are all warmly invited. Thank you very much.